Access to information in the country remains an important exercise for Ghanaians, especially journalists, on the back of the judgment by an Accra High Court for Media Foundation for West Africa to pay 1,500 cedis for information it requested from the National Communications Authority. Godfred Tanam critiques this decision of the courts.
The right to information law is intended to empower individuals and civil society to understand the policies with which the public administration and legislators make decisions relating to health, education, trade and infrastructure, and the objective basis for such decisions. Before the passing into law of the right to information, the Constitution of Ghana already guaranteed every individual the right to information. This was evident in a High Court ruling in 2016 ordering the state to disclose some documents related to bloated contract to brand buses with photos of the then president and past presidents. This led to the resignation of the then Transport Minister Jifar Tivo and a refund of the 4.6 million cedis excess payment for the project. Parliament, as it stands now, is yet to approve statutory fees required to access information in the country. The Media Foundation for West Africa dragged the National Communication Authority to court, demanding the list of all FM radio stations indicating name of company, name of radio station, location and frequency number that it had shut down. The Human Rights Court Division of the Accra High Court, in its judgment, ordered the NCA to furnish Media Foundation with information but pay a fee of 1,500 cedis, which is a reduction of the 2,000 cedis the NCA charged to release the information. Media Foundation for West Africa expressed disappointment over the court decision.
The amount to be paid for accessing information from public institutions should cover the cost of reproducing that information, and we doubt if it will cost 1,500 to print or photocopy or put the information we are requesting on a drive.
However, he expressed satisfaction over the order to grant them the information they requested.
We have been granted 3 of the reliefs that we were seeking. I think this is very important if we are to be able to scrutinize the NCA's exercise in shutting down media organizations that were deemed not to be in good standing.
It is not the first time the High Court has ordered for a fee to be paid for information. For instance, in a case between the MP Mfwa and the Electoral Commission, even though the court ordered the EC to furnish the MP with the said information, it further asked him to pay an amount of 1,500 cedis. But how does this affect access to information?
Parliament not having decided as to the amount to be paid by way of a legislative instrument or any legislative framework to guide that, I felt, strongly that should inure to the benefit of the citizen. The Ghanaians should not be made to pay for something that is presently not legally required to be done. And I was expecting the court to really allow the citizen to enjoy that benefit until such a time that Parliament makes that necessary legislative instrument.
He argued the amount charged by the court is exorbitant.
The amount is really excessive. For an individual who would want to access information, paying 1,500 cedis, that's a salary, a month's salary of most civil servants. And that is so prohibitive that a lot of people might not be able to access information if you go by the figures being mentioned by the court.
Godfred Tanam, TV3 News, Accra.